So this is a little bit kind of crude, but basically, so in the statutory instruments, right? It's an actual update to an act, which is that 1990 Town and County Planning Act. And in the 1990 Act, it sets out what an advertisement is. So we're defining what an advert is and what it can be. And it's talking about word, letter, symbol, but also a representation, something that represents something. A representation, you can, like, theatrical act. Extinction Rebellion have been doing loads of those representations. So that sets out what is an advertisement, what classes as an advertisement. Note that the Criminal Damage Act was in 1971, right? By 1990, anything that's a word, letter, or something, or a representation that means something is classed as an advertisement. So it's got you're defining something. It's not random. It's not like a crack or a break or a sprain. This is an advertisement, right? And once you've established that, you're in the act that deals with advertisements, because that's what the act is there for, to deal with advertisements. And it's all about consent, express and deemed consent. And then when we get this statutory instrument that sets out all the schedules and the classifications, so it's better to see all the parts, right? Part 1 is just the general introduction. And then parts 2 and 3 here, an entire section on deemed consent and an entire section on express consent. Now, those two sections, what I've put a circle around there, 2 and 3, are not relevant to class F, which is when we get into the schedules. Why? Because in class F, you do not need deemed or express consent. You automatically get it with class F. That's why it's exempt, because you're using an enactment which gives you consent of the Lord spiritual and temporal. And you might think that's silly, but the statutory instruments hasn't got consent of the Lord spiritual and temporal. It's made by the government as a statutory instrument based on the previous act, which is the 1990 Town and Country Planning Act. That gives you consent of the Lord spiritual and temporal for the whole act. So, and the statutory instruments is only built up on that. You only get consent and deemed consent through this act. Here, how does this act give you deemed consent and express consent in the act? Because the act itself, you get consent. You're giving consent. It's meant to be poetic, that there is a meaning to it, and there are many more meanings in it. So those are the main sections which don't apply, because you don't need the consent. And then as long as it's class F, you can do whatever it says in the rest of it, because you've got consent, right? Or if you apply class F to any of the other classes, you get consent through the act. Part 4 is just to do with areas. What are the different areas? And some of them are like, rural areas or outstanding natural beauty, and they're dealt with a bit differently. 5 is just miscellaneous things, right? So that's how it's set out in your head, and you need to know that, because the 2 and 3, which is, it's all about, firstly, what are we dealing with here? What is this? Oh, it's an advertisement. Who says? The Town and Country Planning Act 1991 says this is an advertisement, and this is how we deal with adverts now. If it's not an advert, then it's not an advertisement, and you don't deal with it in this act, because then it might be something else, like a scrape, a scringe, a peel, a crack, a pounding, a dent, a rent, a scruff, a muff, a duff, or a tuff, right? Now, then we've got the schedule 1, 2, and 3, right? And then we've got, and also double at the end there, right at the end, we've got the interpretations and stuff, the interpretations and descriptions of it all. Now, in these schedules here, you actually The only one which actually applies is this Schedule 2. And that Schedule 2, funnily enough, is the one that deals with speed cameras as well, which you can't obstruct or block the mechanisms of them and so forth operation, which is ironic because illegal road signage would render the operations to be messed with if the signage was leading cars in wrong. But we'll get onto that at another time. In this number 2 here, it also deals with those mobile structures like the ones that Extinction Rebellion have been erecting. They're dealt with in this act because they are a frame or structure for placing an advert, which can be a representation. So, and that is the one which actually you can have that in Class F. But actually, funnily enough, in the first one, you definitely get it through the right to petition because it gives you consent. Who's giving you consent? Well, you're getting consent from the law not to be liable to be prosecuted when something's for purpose of petitioning. But we can argue about that separately. But, when I got prosecuted, they didn't even mention this act or the law or anything, or even raise this Schedule 2 in. They were interested in it. If they had raised it, then it would have raised questions about them causing, obstructions to their own equipment and hindering their own equipment. So that's why they didn't really want to raise the matter. But anyway, so number 1, this is where it's setting out all these classes and, A, B, C, D, E, and F and so forth of defining which different things are. And then you've got the third one, right? So this is where it's saying, part 2 does not apply to F and so forth, and, the deemed consent ones. Now, you've got some other classes as well, right? And one of them, not in the class A, B, C, D, E, and F, in the part 1 of the specified class conditions deemed consent granted, though, you've got this class 3D. It's almost like 3-dimensional, right? And you've actually got a size limit on it, which is 0.8 meters, right? But it says that's for political events. It says a political event. If it's an advertisement for an event, well, an event is on site, like if you're going to hold a meeting or get people together in a park or something. It's actually not to do with actually petitioning the government directly, saying, will you sign this petition somewhere? Because that's not an event. You're saying, if you want to stick or place in notices asking people to go on the government website to sign a petition, what event's that? You're not in a park or doing an event anywhere. And it's dubious whether these Class 3D is even legal because, is it compatible with the right to petition? Because it says all prosecutions are illegal, all of them. So, there's a question of, is this act even compatible when it's enacted? And is this Schedule 2 even compatible when it's acted? That is the irony in it. But let's just, it doesn't really matter about, because it's not political events. It's not promoting an event. It's actually asking the government for action or getting governments to do something about a matter that's been drawn to the attention of Parliament. So Class 3D actually isn't relevant unless you're asking people to turn up at specific events on certain dates and so forth. I don't even think that there's questionable to whether this is even legally enactable anyway, like a lot of the things that the government claim to be doing. So it's all about this omission of this 2 and 3, which is your deemed consent and express consent, because you don't need it. And they're for commercial adverts when you have to get permission and pay for them. You don't need any permission when you're doing it politically. Why? Because you're using the right to petition and you got the right to do it, and you can't suffer any consequences for doing it. The council can't issue any removal notices or anything like that. And I don't think they can obliterate them either, because you would be held to commitments of this act. The right to petition says that all commitments are illegal, so you shouldn't be able to be held to any commitments of this act. But effectively, you are pretty much exempt from this act. Anyway, now, in these classes, right, Class E is elections and referendums and so forth, which, candidates, government officials, councillors and so forth. But you can also petition for a referendum. and a petition for a referendum is in connection with a referendum, and it's deemed in the same class all through the Elections and Petitions and Referendums Acts. Class E and F usually come together because when you're petitioning the government, you usually can have a referendum about it if enough people sign, unless it's like petitioning for an inquiry, which is like an investigation, or if you just want the government to make or change the law. So, but Class E and F usually, when it's political, come together, or if not, Class F also can be, maybe the police can use Class F. For example, if the police are this is all about advertisements, remember. So the police can put an advertisement out for witnesses to come forward and so forth, and you can't intervene in that because no one can intervene in the pursuit of criminals, or hinder or obstruct you, right? Like Criminal Law Act 1967, 4, 1 and 3, for example. You're doing something to pursue criminals, no one can intervene. That's another enactment that can be used in the Class F, but that's not the right to petition. That's just an example. Criminal law, the Criminal Damage Act 1971. If the fire brigade are placing signs anywhere or have to put a notice on somewhere, even if it might be a risk of damage or cause to damage, then if the fire brigade just breaks something and there's no meaning to it, they're not giving a message, then it's Criminal Law Act. As soon as you're getting an advertisement or a notice or a sign, you're doing it through this act, right? I mean, the fire brigade might need to say, there's some broken glass there, be careful, or caution, or whatever. You're advertising danger and so forth and things like that. This is just an example. This is just an example. So, I mean, you really need to split this act up into its section. If you look at it laid out in front of you and all the different parts and sections, what they all are and which ones are relevant and which ones aren't relevant, it's dealt with in this act. There are two main things in this act. And first is it an advertisement or not? If it is, then you're in the right act. If it's not, you're in the wrong act, because criminal damage is not about advertisements, right? If it is an advertisement, then it's this act, not that act, because a scratch, a scrape, a dent, a peel, they are not a advertisement, right? Unless you go to use a representation of something, the person wasn't intending to put a sign up or whatever. It's a sign that someone's angry. That is, stretching the extreme limits of, I was very angry about something, so I wanted to, give notice by putting a dent in the wall in the police cell or something like that, or, scraping the name in it, I was here. It's giving notice to something. Are you petitioning the government for action through it? Is questionable. But that's not relevant to this now. We're talking about this act. Now, what is an advertisement to start with? It's a letter, word, sign, representation, right? So the first argument or thing to ascertain is, was Gail Bradbrook breaking the window and having it being filmed to give out, to promote or advertise a message to someone? Did it have a meaning? Did it represent something? So was it a communicatable message, a sign? Either it was or it wasn't, right? Now, if some chavs are walking down the road and scrape, punch, break, etc., damage, is it meant as an advertisement? Unlikely. The fact that Gail was being filmed and she was doing it on behalf of a cause to raise awareness of something, and it had a meaning, like, these banks are corrupt or the system is broken and so forth. You're getting into representation, which is that what they've been doing with all their acting and theatrical enactments they've been doing. Theatre, basically, is theatre is a representation. So if it's done as theatre, it's an artistic representation. That's for sure. I think under the Town and Country Planning Act 1990, it is a advertisement and representation. Therefore, we get to the statutory instruments, which elaborates on it and adds in further provisions. In the first act, it qualifies for advert. And then this is how we apply to the different types of adverts. It's a political advertisement and it's Class F, using the right to petition. And what does that enactment do? Stops you from suffering consequences. It's immunity, protects you. You can combine these classes together because it says like one or more classes in use. Well, you can combine E and F, which are combined a lot, like I've said, on A, B, C, D. Now, C is painting surfaces. And that's a legitimate class, painting a surface of a building, whether it's public or private, and it's dealt with under deemed consent. If you don't have deemed consent, then you suffer consequences, and there are certain provisions and processes for removal and fines and so forth, but not if you had consent. In fact, if it's private, the person has to pay for it. If they want the council to sort it out, they have to pay for it, right? That's just how it is. The right, Class F and the right to petition, the addition of that class gives consent. You can use C, so you can paint, you can have C, E, and F, or you can have C and F, or you can have E and F, right? Now, the only problem is that it definitely is an advertisement, because it said a representation is an advertisement through the act, through the 1990 Act. This is a statutory instrument, right? So if it is an advertisement, then it isn't criminal damage. It's not criminal damage, because then it would only be a scrape, crack or whatever. If it is a representation, then it's this act. Now, have you got consent or not? And, what are the consequences for it, being put on, what are the consequences for doing it without consent, or, without in the regulations? This is it. There are specific fines or fees and so forth under this, and offences, but if it's an advertisement, it's not damage, because damage isn't an advertisement, is it? A crack, a scrape, a peel or whatever is... What is this? This is damage. What is this? This is an advert. Did you have consent or not? And if not, then you will be punished for not having consent, but not for damage, because it's an advertisement. This is the thing. But the police get all within this, peeling, scraping, sticking. Yeah, if it's not an advertisement, the police love this. Criminal damage, stick, scrape, stick, peel, paste. Yeah, I can stick, scrape, peel, paste a twig. I can scrape, scrape, paste a paperclip. I can scrape, scrape, paste, paint, or whatever. But is it an advertisement? And was it intended as an advertisement? Is it classified as an advertisement? If it is, I'll see you later, 'cause it's not criminal damage. Bye-bye. Good day, sir. And we'll be dealt with under here. And whatever fines it says, if they didn't have consent or not, and so forth. And in fact, if it's private, the owner can contact the council to remove or remedy it. Paint is not deemed to be incorporated into the fabric of the building. Now, I don't think there's any, was this reasonable action? Was it proportionate action? Let's measure it. Nothing to do with that. Either it's an advert or it isn't. Either it's Class F or it isn't, and either the representation, which is an advert, is provided for in these classes, if not Class F. But Class F, notice with Class F, it's an enactment, but it doesn't say what you can and can't do in Class F. There's some sizes under Class 3D for political events in size and so forth. How big was the crack? This is it. So the argument is over. Can you fit a representation which is going through the fabric of the building? If the crack is therefore incorporated into it says the paint is never to be regarded as incorporated into the building, even if you paint it on the surface, even if it soaks into the light, to the stone between it. Legally, when you paint an advert on a building, It doesn't matter what the paint does, whether it seeps between holes or whatever, or into the wood or whatever. It legally is not. If it's an advertisement painted, you can do that, and it will not be incorporated into the fabric of the building legally, right? So you can remove it for a fee, and all that removal and cost is dealt with by removal fees and costs if you don't have consent and so forth. But if you did, then you had consent to do it, so you're not guilty of an offence, and in Class F exempts you from the consent. You get it automatically because you get consent through the right to petition. That's the whole point. There is no weighing up and balancing. It's on off. It's Class F or not. It is an advert or it isn't. Representation or it isn't. Now, is the representation? Well, this is the thing. When the chisel hits the, what is going on? It's more than just, this is, it's theatre, isn't it? It's like a publicity stunt. That's the word, publicity stunt. It makes you wonder about all these accidents where men crash into schools, and 8-year-olds have been injured recently, but he's apparently had an epileptic fit. Was that a stunt by the police, by 77th Brigade undercover? Because at the end of the day, it gets public concern. The thing about inquiries and so forth is they're always after public. Oh, is there public concern? Is there public concern? It starts to make you think whether the police are using some of these criminal law acts and damaging their immunity covertly because they've got a right to. Oh, well, there's evidence that would the public be concerned if a car crashed into this building? Well, let's see. Let's find out. I'm immune. And we could do it covertly. Look, I'll get a couple of officers who are off work. Don't worry, we'll deal with it. Site management. Make sure only certain news teams turn up. We'll see if the public are concerned. Oh, look, evidence of public concern. Now we've got that. Now, this is it. Are the police always after pursuit of public concern? And if there isn't any, can they create it? Can they make public concern? Oh, we want more speed cameras and security. The public don't seem that concerned, but we really, really want this security so we can watch them. Oh, well, we'll have to make them concerned then. Oh, they will be after with, tell them there's paedophiles everywhere. Get them scared. Weirdos, paedophiles. Get fences around schools. You can't have your kids out in public. But then again, Sir Ben Bradshaw, MP, ex-BBC. Oh, we'll have to be teaching them all about sex in schools at a very early age and all about anal sex. I thought we've built fences around schools to keep weirdos out, not give them jobs as teachers and teach the kids about anal sex. This is it. Who's protecting who here? So as far as I'm concerned, it's a publicity stunt, publicity being advertisement, which is a representation using Class F alone or the right to petition. There wasn't any paint involved in this particular one.